Yes, yes,
Yes.
you place your case.
Hello, hello. First, my respectful submission before your lordship would be on a very fundamental issue. While I was trying to look for that, in fact, it is because of my learned junior, I could get inspiration from the language of a full bench judgment where the language was of your lordship. My lord, first, recruitment and selections are not necessarily the identical thing. Recruitment is something which stands on a broader aspect. When the employer decides, I want to go for a recruitment for X number of vacancy. Citation.
Yes.
Well, there are two sides. One sides who are called as the promotees, they are already working. There is another side who are the direct recruitees yet to be appointed, and their rights come once there is a decision for a selection process to be initiated. My reason of saying is this, that the parameters to see what kind of rights of these two groups of persons, when lordship would be testing, then lordship would probably would be taking into account that there are some persons who are working and they are already in service itself, and there are some other persons.
You are working and you are getting the icing on the cake also, the promotion.
Yes,
But that is not with the direct recruits.
that is not with them.
So how you are bothered?
No, I am bothered.
It is not that your life has ended. You will get your promotion. No, Mr. Dhar, why you are segregating between recruitment and selection? We are not we are simply wanting to know what is your challenge to the note. Satisfy us.
Well, I'm coming to that.
Cut it short, Mr. Dhar, because
this is
the only challenge which I find if you come to the prayers of the writ petition, it is only challenge to the memo of 7 September.
Once I formulate,
that takes us to a very winding out process. Today, if in judicial review, if we have to consider all your arguments to that effect, then it becomes immaterial matter. Will not.
I have not even. Once I complete
we are suggesting that you restrict yourself on the acceptability of the note and how you are aggrieved and how you are challenged.
I would. Just to may I just complete my this sentence and directly I will come there. Just allow me just complete by one or two sentences. I was only trying to say this. A direct recruitee, his right does not exist to say what would be the number of vacancies in a recruitment process. All I'm trying to say this. My reason of being aggrieved was that in 2015 onwards, my lord, the number of pool where I can get my promotion was made to 50-50 by the central government. Now this entire recruitment process is by funded exclusively 100% by the ICDS central government scheme. State doesn't pay even 1 rupee for it. Now central government decided that there is a requirement for the persons who are already working there as Angonani workers, some impetus has to be given so that they can be promoted. So therefore, pre-15 situations was 75-25, no quarrel about it. But post 2015, it should be 50-50, meaning thereby if there are 3,000 number of vacancies, the 1,500 should go to us who are working there. Now, my lord, I am putting a question to myself this. What the state government is trying to interpret is as if the direct recruitees, they have a right to hold on the carry forward of all the number of vacancies where recruitment did not take place from 2015 to 2019. The question today is 2019 is the recruitment process has been initiated. 2019. Now in 2019, when the recruitment process is initiated, the requirement of the state should be to follow what? Should the state then go back to 2015 pre and find out what fault I make and thereafter make a calculations and then cut my 50% or not? Well, that's the way I'm agreed.
That ought to have been a public interest litigation then. Because
Yes.
we are at the stage of the recruitment rules.
Yes.
Recruitment rule specifies a particular clause.
That is 50-50.
50-50.
Yes.
No. Recruitment rule clause 3B note.
Yes.
Note. Come to the note of the notification.
Note is clear. Note says the learned single judge has said that why this artificial distinction is being made.
Now, Lordship, may I read the note?
That is page. Kindly come to the note.
Yes,
page
I'm on the note. In case of vacancies,
a clear mandate given.
Correct.
You are arguing, if we are not wrong, you are arguing on the basis that when is the right of a selectee is born.
Yes.
That is, you are making this argument to support your plea pertaining to the stagnation of promotion during the stagnation of filling up the post.
Yes.
That is linked to that.
Yes.
But today,
yes,
on the basis of this writ petition, you have not challenged the note also.
Well, I have challenged. Lordship, may kindly see page 31.
Yes, page 31.
Page 31, kindly take first paragraph.
This is not a comprehensive writ petition challenging the argument which you are advancing.
So may I say this?
There is no pleading to that effect in the
what I have, if I say in one sentence, I have challenged the reduction of post in my pool in first paragraph of 31. Lordship, may kindly have a look at that. I say by following their own rule that can't be done.
Why do you say so?
Yes, madam, may I place in, I am directed to inform you that 55th meeting of cabinet held on 21st of February 2019. Lordship, may kindly mark the date.
Yes.
Has approved VDA number of such and such, dated such and such, Roman 1, recruitment rule for the post of supervisors under ICDS. Roman 2, filling up of vacancies of, kindly see my lord, filling up of vacancies of 3,376 posts of supervisors on the newly framed recruitment rule, of which 422 numbers post will be filled up by promotions by selections from Anganwadi workers. All I say, 2019, you yourself say number of vacancies is 3,376. 2019, the operating law is 50%. Now, half of the 3,376 is 1,688. I am aggrieved because of 1,688 minus 422, that is, I am aggrieved by 1,266 is reduced. There I say, one selection process is initiated. If it is not initiated, that's a different thing altogether. The whole set of judgments based on when the game starts. If the game has started, of course, it has to be guided by the rule prevailing on the game. But the game starts.
Rule says that we are demarcating this procedure.
Now, yes, true.
You are saying that the rule is bad.
No, I'm not exactly.
Citing paragraph 1 of page 31. Your indirect challenge is to the note. Your argument is that 7th of March 2019, what was the ratio applicable? 2019, it was 50-50. I come to see from this that 50-50 is not being maintained.
I put it in this way. May I say this? I get the point. I say that in 2019, what is the total number of vacancy? You yourself decide. You yourself decided that total number of vacancies is 3,376.
Yes.
Now, once you have decided that the total number of vacancies is 3,376, Thereafter, what happens? Is there any requirement to follow 50-50 of 3376? Or the note will control the entirety of the 50-50?
Will it not? Because that is the prescribed notification.
It could have if the game had started. That's I'm on. If the game had started, meaning thereby that some form of some kind of recruitment, that we are going to go for recruitment, or we have taken steps to declare the number of vacancies.
Did you challenge that while participating?
Well, I have not participated in the direct part. My participation was for a separate thing, because I have to fulfill 10 years and there is a written examination.
So, but you participated, na?
I of course participated, my lord.
Exactly. Otherwise, you would have lost that right.
Not this one. I participate in a separate avenue for getting promotion.
Maybe, but that is pertaining to the rider which has been specified under the rules.
My lord,
they are holding the examination on the basis of that, bifurcation of 75-25 or
Lordship, kindly consider this for a moment. For a moment, kindly assume that there is, for the sake of argument, non-existence of the rule. But I will go by the concept of that whatever the rules in existence, we should govern ourselves by that. All I submit is this: if the recruitment is not done, because the chart that Mr. Banerjee has handed over, that recognizes some extra promotion was given pre-2015.
498.
And 498, and therefore that's an excess promotion. Lordship may kindly consider this. Today the rule says that total number of vacancies, it should go 50.
That ought to have been your writ petition, Mr. Dhar.
My writ petition.
That argument,
yes.
That argument you could have made, yes, subject to be corrected, yes, provided there was proper amendments to that effect and pleadings in the effect.
But that
is not there, Mr. Dhar.
But what I say is,
now, when you do, we are not stopping you to challenge the declaration of vacancies later.
No.
If on the basis of this red note,
yes,
if it is made 50-50, yes, and if somebody else who does not belong to this arena is being inducted,
yes,
that is a fresh issue for you to be considered before an independent.
May I say? What I challenge is the act of reductions of 100 and 1206.
Understand that. That is paragraph 1 of page 30.
Yes. I say that, I take your words. You say the total number of vacancies is 3376. You don't say, you don't give the picture of that I made a mistake before 2050 and therefore I say that the rule, if we come back to the rule itself, page 31, na? Ruleta kothay ache dekho to?
গেটটা হয়ে যাবে।
গেটটা বলো তো?
যদি মিস্টেকে যদি বেশি হয়ে যায়, তারপরে যদি 50-50
why
বেশি হয়ে যাবে?
Lordships might be required to look at the very context also. The context number 1 is the 100%.
Say note cannot, just a note. Notice for clarification.
Occurring of the vacancy, all I'm trying to say, has to be a decision for selection process. The note will only apply when there is an occurring of vacancy. Had there been an occurring of vacancy pre-2015, no difficulty. The occurring of vacancy by their own notification was in 2019. Once the occurring of vacancy happens in 2019, I put a question to myself. What is required to be followed? Because the language of the note, in case of vacancies occurred up to 30th September 2015, that's a restriction. So therefore, selection process, there was no such occurring of vacancy at all. There was no decision that we are going to go for selection. It's a prerogative of the state. They can very well decide, we may have 3000 pool. We don't want to go for a total number of vacancies to be filled up. So therefore, we want to restrict to 50. But because we did not do so 10 years before, today we will make our calculations. The result would be, my lord, we get only 422. And lordship, as I was trying to, my lord, make this submission that in every case, little bit of here and there change in the context makes a tremendous impact. Like in this case, the decision was by the central government who provides the 100% money for this project. Now 2019, they themselves also adopted the rule. I could have understood that the vacancy notification or selection process being initiated pre-2019. Now rule is amended, rule having been made as 50-50, and thereafter, my lord, going back to this concept of that I made a mistake pre-2015, that itself would be violative of the very rule itself. Lordship, kindly consider this.
We have extensively heard Mr. Bandyopadhyay. No, we have extensively heard Mr. Bandyopadhyay learned advocate appearing for the
493.
You are the appellant in both the appeal.
Yes.
Both the appeals. Appellants in both the appeals.
So list
Mr. Sengupta learned senior advocate. So Bandyopadhyay learned written plan. Mr. Sengupta learned senior advocate. We have also heard Mr. Sengupta learned senior advocate appearing for the applicants in CAN 4 of 2024 filed in connection with MAT 493 of 2024. The CAN 4 in MAT 493, na? CAN
Yes,
4 in 493. However, due to paucity of time, Mr. Dhar learned senior advocate appearing for the appearing for the writ petition or respondents.
No, well, Lordship, because originally I was not the writ petitioner, somebody else.
For the
509, that number.
Yes,
for the promoters. How it was Mr. Dhar learned advocate, Mr. Dhar senior advocate could not complete his argument. In view thereof, please the matter for further. তারপরে ওটা লিখে দেবে ওই let the exceptions to the report, as file, be kept on record. ওনাদের সবার appearance-টা দিয়ে leave the matter for further consideration in the.
Your Lordship is keeping it. Is keeping on.
We have not yet.
That is yet to be.
We are yet to keep it.
January, yes.
We want to finish it.
And your one thing, we also want that your Lordship finishes it. Because in the unlikely event of a change of page, and the Baki part.
Before 13, there is a change.
I do not know. But in the unlikely event,
It is urgent.
your Lordship has, Lordships have, they have for the almost entire thing, this way and that way. And that is why
I also have circuit, Mr. Sengupta. My brother also has circuits.
when
That we won't not disclose.
even then, it is part
We
of
are not going prior to 13th. We will go after that. So before that, if we can finish with your assistance, then all right, we can deliver the judgment. We had this problem in the School Service Commission matter. Many councils were appearing. We requested them that this will come on 13th and finish it off. And Mr. Bandyopadhyay, you also be here to whatever reply you want to give. Please finish it off on
13th. We do not consider usually in our culture as anything bad. 13th is nothing wrong. We have 13th seat also.
Don't forget that.
Well, only one short point. Can 6 and 7 we will address on 13, not more than 10 minutes, man. Can 6 and 7.
Sir, we are keeping it at 2 p.m. Without your assistance, we cannot finish. So we hope that you will assist us and finish your argument so that we can deliver the judgment. Good, bad, indifferent, higher forum is there. So we request all the councils to finish it off on 13th. 13th কিছু নেই।